Can you handwrite your will? Can you just write out on a little loose leaf piece of paper your intentions and declare that to be a will? Hi, I'm Darren Findling of the Probate Pro, and in Michigan, there is no requirement for a will to be typed out, whether it be by typewriter or computer. And in fact, it contemplates that many people will actually handwrite a will. You can imagine scenarios in which this occurs quite often. It occurs quite often with suicide notes. It occurs among elderly who don't have access or familiarity with a computer. And it often occurs in rare circumstances where somebody is trapped, like a person trapped in a cave or a mine, where they're writing out their last wishes on, for example, the walls of a cave. We've seen wills scribbled on inside Bibles. We've seen wills scribbled on envelopes and in other loose pieces of paper. There are some requirements that must occur for the will to be valid. First, it must be in writing. It must be signed by the testator or in the testator's name by some other individual in the testator's conscious presence and by the testator's direction. So imagine if somebody was unable to actually sign, but it is being done by another person in their conscious presence and in the testator's direction. It must be signed by at least two individuals, each within a reasonable time that it's being witnessed. Now, there are exceptions to these strict compliance requirements for the execution of a will. So, for example, you may have heard of a term called a holographic will. A holographic will is a will that is substantially in the writing of the person that's signing the will. It loosens the requirement of witnesses. So as long as it's dated and signed, a holographic will can also be valid. And then there's this great catch-all statute that Michigan has. It says, although a document or writing is not executed in compliance with those strict requirements that I've just said, a writing is treated as if it had been executed in compliance with the statute if the proponent, meaning the person advancing the will to the probate court, establishes by clear and convincing evidence that the decedent intended the document or writing to constitute a will. So imagine if the document doesn't have two witnesses, but it's typed out. It doesn't meet the objectives of a holographic will, but clearly on its face, you can show that it was intended to be a last will and testament. So the idea is that intended documents to be aren't going to be thrown out of court simply because there is a mistake in how the document is executed. It serves public policy that people's intentions should be fulfilled. Now, there's a whole body of law and cases that have addressed this issue. Recently, Michigan addressed a case in which a suicide note was done on somebody's cell phone. And there have been other cases in which the document actually wasn't even signed, but was about to be signed by the seller. So all different types of situations. If you've got questions about probate issues, visit us at theprobatepro.com or call us at 833-PROBATE.